This Honorable Court of Tennessee is now in session.
Welcome to the October session of the Court of Criminal Appeals for the Eastern Division of Tennessee. First, let me express our appreciation to Nick Morgan and Francesca Kraft on everyone's behalf for helping us work this logistically and get everyone into the hearing and out and all the things that have to be done. Our panel today is Judge Camille McMullen from Memphis, Judge Jill Ayers from Clarksville, and I'm Kelly Thomas from Maryville. Each side has 20 minutes to argue, and the state is the appellant or the moving party in this case. If the state wants rebuttal time, please let me know when you start. I will give each of you a notification, let you know when you're within about 2 minutes of whatever deadline is appropriate. So you can, start wrapping up whatever else it is that you need to say. It is a little bit difficult doing this because when you ask something, you sort of automatically interrupt the person that's speaking. Mr. Anderson, I'm presuming that you've never argued before in appellate court before, and it's not like a regular courtroom where a person can object while the other lawyer's arguing. Neither you nor Mr. Ward are to voice any objections to what the other says. So Mr. Ward will make his argument first, and then Mr. Anderson, we will give you 20 minutes to make your argument. And then Mr. Ward will have whatever rebuttal time he wanted to keep afterwards. Everybody, Mr. Anderson, do you understand?
Yes, sir.
Okay. All right. Thank you. General Ward, you may, so we haven't called the case yet, have we?
No, sir.
Would you do that, please?
State of Tennessee versus Stephen D. Anderson.
Okay. General Ward, you may begin.
Good morning, Your Honors. May it please the court. My name is Garrett Ward, and I'm here today on behalf of the state in the matter of State versus Stephen Anderson. And please, Your Honors, I'd like to reserve 5 minutes of my time for rebuttal.
Very well.
Your Honors, we're here on state appeal following the trial court's dismissal of the state's indictment for driving under the influence in violation of the open container law. And Your Honors, to sort of understand what's going on in this case, I believe it's helpful to briefly run through what precisely occurred here from a procedural posture. In August of 2018, the defendant in this case was arrested for driving under the influence after after a law enforcement official observed him driving southbound and northbound lane. Again, that was in August of 2018. Around 6 months later, a little less than 6 months, in February of 2019, the Cott County Grand Jury returned an indictment formally charging the defendant with the aforementioned crimes. The case sort of proceeded onward, had not yet reached trial, when in August of 2020, in March of 2020, the defendant filed a motion to dismiss the state's indictment. The defendant, although represented by counsel at the time, did file this motion pro se, but the trial court did exercise its discretion and considered the motion. And in essence, the motion raised a sort of a statute of limitations based claim, suggesting that the state had commenced prosecution after the statute of limitations had run. The trial court held a hearing on this motion. And at this hearing, the state explained that in fact the state had returned an indictment around 6 months from the date of offense, so well within the year-long statute of limitations for driving under the influence. And the trial court being satisfied that prosecution had commenced within the appropriate statute of limitations, denied this motion to dismiss. However, after the motion to dismiss on sort of statute of limitations grounds, after that motion was denied, the defendant requested that the trial court set his trial for August 20th, 2020. This hearing where this request was made was held on August 18th of 2020. So the defendant made an oral motion to essentially set his trial 48 hours from the time of the hearing. The trial court essentially interpreted this oral motion as a speedy trial motion, noted that the state had not found that the state had not committed sort of any wrongdoing or negligence in terms of commencing and going forward with prosecution. However, the trial court did decline to set trial for 2 days from the date of hearing on the grounds that at the time in Cott County, again, this was August 2020, that the coronavirus pandemic was presenting sort of a great public health risk, and the trial court was properly concerned about the health risk that a trial would pose to the jurors, potential observers, and the participants. So
at this point, General, do you know how long Mr. Anderson had been in custody?
Your Honor, Mr. Anderson had been in custody since the date of his arrest in August of 2018. But it's important to note, Your Honors, that while the defendant had been in custody, from the record, what we know is that his August 2018 arrest for driving under the influence was the basis for a parole violation. So he was in custody from August of 2018 until the date of this hearing. But the basis for his incarceration at this time was not solely this pending DUI charge. It was the underlying charge for which he had been paroled. So it's not as if he was sitting for some extended period of time solely awaiting trial on a DUI prosecution.
Do you know if he had made a bond?
I don't believe he had, Your Honor.
Okay.
I can't say for certain, but from the record, it appears that he was in custody that entire time.
And one other question.
Yes,
was the parole violation a hold, or had there already been a hearing and his parole revoked? Or is that even in the record?
The record is not entirely clear on that point. What the record reflects regarding his parole violation is largely reflected in the comments of his counsel at the time of this hearing. The counsel briefly explains, and this is in volume 2 of the record, on pages 9 and 10, his counsel explains that the DUI arrest was the basis for a parole violation. He doesn't give any more specifics than that, and further explains that he's been in custody since that arrest.
Okay, thank you.
So at this point, Your Honors, as defendant's counsel is discussing this parole violation for which the defendant's being held, his counsel essentially asked the trial court to dismiss the indictment in the interest of justice. The trial court essentially asked the state at that point if it will consent to dismissal, and the state objects. The trial court, while specifically noting that the state has not been negligent or committed wrongdoing sort of with the steps taken in this prosecution, the trial court specifically notes that, and then nonetheless dismisses the indictment. And it was shortly after this indictment was dismissed that the state filed its notice of appeal in this case from the order dismissing the indictment. And Your Honors, the state's position here is relatively simple, that Tennessee law does provide trial courts in certain circumstances the authority to dismiss indictments. The jurisprudence on this, though, is very clear that trial courts do not have any sort of wide-standing inherent supervisory authority to dismiss indictments, and that dismissal of an indictment is a remedy that should be exercised sparingly. Your Honors, from the Tennessee Rules of Criminal Procedure, from the jurisprudence on indictment dismissal, there is no right, there is no legal basis for dismissal simply in the interest of justice. What it seems, the positions articulated in the defendant's motions and arguments, it seems that his argument is truly that this prosecution was commenced outside the statute of limitations. As I mentioned previously, this prosecution was commenced within 6 months of the offense date, well within the statute of limitations. The trial court clearly did not feel that the prosecution violated any statute of limitations grounds, so did not dismiss the indictment on that basis. The trial court also noted that the state had proceeded with the prosecution properly. The trial court does not, sort of in denying the defendant's speedy trial motion, this is the motion the defendant made to set his trial date for 2 days from date of hearing. The trial court makes no finding and makes no suggestion that the state has conducted any sort of behavior that would potentially lead to a post-indictment delay speedy trial violation, which in certain circumstances can be the basis for indictment dismissal. What it seems happened here is the trial court, essentially under a supervisory or inherent authority basis, dismissed the state's indictment. Tennessee law is clear. The Bragin case, which I cite in my brief, very explicitly provides that there is no sort of wide-standing authority under a supervisory authority theory for a trial court to dismiss an indictment. That's essentially what happened here. And the state would ask that because the trial court's dismissal of its indictment was done without a proper legal basis, that this court reverse the decision of the trial court. If this court has no further questions, I'll reserve the remainder of my time.
All right, sir, thank you. Mr. Anderson? I show that your microphone is muted. There you go. All right. You have 20 minutes if you wish to argue to your position as opposed to what the state has been arguing. So we will hear you now.
My name is Stephen Douglas Anderson. I'm a resident of Morristown, Tennessee. I was arrested in August of 18 on the charges of the DUI, an open container, and the next day I made bond. I was out from August up into, I believe, October 5th of that year, and the parole people violated me, and I went in my parole meeting and I was arrested. I was incarcerated until May of this year on the charge that I received in 1985 for receiving and concealing stolen property. I'd made parole on that charge in 96 or 97, my memory serves me right. And I was on parole and I was violated twice for DUI. First time I was arrested in, I believe, 15 in Cocke County, and the charge is dismissed because the vehicle would not operate. And you cannot charge anybody with DUI and a vehicle will not operate. The second time, I'd made bond and I got violated, and my understanding of the statute of limitation is 1 year after commencement has been started. And the district attorney seems to believe it's 1 year after an indictment started. Now, his argument about the judge properly dismissing it under the law is not stated, so he might be correct. But my thinking is the 1 year statute of limitations had well run on me being prosecuted on that charge. And as if the judge not ordering a hearing 2 days, a trial 2 days after it happened because of the COVID, I don't really have a argument either way. And, but my thinking is the statute of limitations had run, so it's irrelevant why the judge dismissed it. And if every judge put down every reason every time they dismissed a case, court would be going on a lot longer. And my brief speaks for itself, and I'm going to go with that and let my argument end. Thank you very much.
Thank you, Mr. Anderson. I appreciate your argument. General, do you wish to make any rebuttal? You have your 5 minutes if you want to use it.
No, nothing on rebuttal, Your Honor.
Okay. Well, I appreciate your gentleman's attendance and your arguments. We will consider the record and your arguments and briefs and issue our ruling. You all may leave the courtroom that we're in, and Ms. Kraft, if you would place us in recess.
This Honorable Court of Tennessee is now in recess.
Thank you.